What was brought to the table that you're rejecting?
But they offered to pay some amount.
How much?
No, that is.
Whenever I say my PENDREAM TV there, I see them yopo.
This is what Dr. Justice Adam Sremsai had to say regarding the questions by the minority and Samuel Atachian. Take a look.
Cannot be an accurate description of what happened. I mean, this is a case which has been tried fairly with a lot of the discretion during the trial exercised in favor of the accused person. The question is, if this is a political persecution and they believe strong, that means that you believe strongly that you are innocent, right? If you are innocent, the manner in which you even conducted yourself to the latter end is as if you knew that you didn't have a defense. And I don't know if you have had the opportunity to read the judgment, but most of the evidence that we have, the pieces of evidence that we have, which the judge relied on, came from their defense. Defense witnesses, the accused person's own comments, his own witness statement, his own police statement. Those were the materials that formed the basis for the conclusion of the judgment. So it will be shocking. It is shocking to me, but that they would say is political persecution. But I understand what we do. This is politics in a way. I mean, what they are doing is politics, and they issued that statement, or they had a press conference when they have not even seen. They had not seen the judgment. So do you expect them, now that they've seen the judgment, they will go back and say what we said was wrong? They would never do that. They would rather double down and say things. But so far, I don't think anyone has pointed to any aspect of the judgment that they believe strongly that is so erroneous.
Should the constitutional matter that Samuel Atachian raised in court have stalls the reading or the decision making of the judge at any point at all?
So when you raise a constitutional question in the lower court, the Constitution says that the judge ought to first examine your issue to determine whether it's a legitimate issue. If the judge finds out that it's a real and genuine issue, then he has to stay the proceedings and make the reference. And if the judge finds out that it is not a real or genuine issue, the judge is supposed to dismiss it and proceed with the trial. And if you don't agree, then you appeal against the judge's decision. The policy reason is simple. Someone who doesn't want the trial to continue will just be raising constitutional issue today, and then you call all the 9 judges in the Supreme Court to decide, and after that he will come back and raise another one. So the rules are designed, or the principles are designed to make sure that you don't use them. We call it abuse of the court processes. And for us, that's exactly what we saw in this matter. It was an attempt to abuse, to use the court processes or court rules to delay the trial and to prevent a decision from being reached. And it was not difficult for us that the judge dismissed it. The judge saw through it because there was no real genuine issue. What they were saying was, you have pleaded guilty to a particular count. You did not raise any issue. You've gone through trial. Trial has ended. You have filed your address, which is the final act that everyone does. Then you come to say, oh, I think what I have pleaded to, I have provided witnesses to do was vague. So I want the court to. That is not to say that you cannot raise it, but when you raise it that late, chances are that you are not being genuine. And in this case, they were not genuine.
And so you must have heard that the counsel for former counsels had to describe him right now, but he told us that, look, on the last day of the trial, Chairman Wontumi called me and he says, look, if this goes south, I want you to appeal for me. So you must have heard that they are planning to go on appeal on this.
I found it strange that actually happened. Oh. And it gives me a lot of, it supports our suspicion that swap of counsel which happened between the close of case and the judgment was only designed to delay the case, because you said you don't want this lawyer again. I want Atachian to come. Then, after you have been convicted, before you go to court, you reportedly had told the lawyer that you didn't want that, oh, if I'm convicted, I want you to continue to represent me. It tells me that you clearly have a design, or you had a design to delay you just did that thing to delay the process. So that itself, I find it very strange. And when I heard it, I was like, okay, it's clear to Ghanaians that this whole thing is just a drama to frustrate the cause of justice.
In the state's view, is there anything to appeal?
We don't think there's any proper basis for anyone to appeal this decision. Of course, the right to appeal is guaranteed. You can appeal, but I do not think that any appeal will succeed against this case, as I understand it.
The Attorney General's office had referred some cases to do with illegal mining and members of the NDC to IOCO. And it hasn't moved as fast as the Wontumi Samre boy case. The question they are asking is why?
There's actually no basis for that claim. When was Chairman Wontumi arrested? Somewhere August last year, year. When did the Attorney General direct IOCO to do this investigation?
I think Chairman Wontumi was May of last year, and this one was July of last year.
Okay. So you see the difference, right? Actually, Chairman Wontumi's investigation started in 2021 when this minority people were in government. So that's like how many years now?
5.
So if it took 5 years to get into, on what basis are you saying that it didn't? This one is not going as fast as the Wontumi one? So you see some of these things when you listen to the minority sometimes and you just apply the facts, you will see that there's more of politics than any factual analysis of the situation.
But what kind of...
Many other people were arrested long before the AG gave a directive to IOCO to investigate. They've gone to BNI, they've gone to IOCO, they've gone to police, but they are not yet in court. Because investigations take time. So if you are saying that, which month did you give?
May and July.
July to July. As compared to some of them who were invited, or some of the former government officials who were invited way back in January, February 2025, and they are not yet in court and their investigations are not yet concluded. So you see, if we want to use that timeline, then it's even too early to be talking about these.
So where is the state in pursuing those cases?
Investigation is still ongoing.
Okay.
I mean, obviously, investigation is still ongoing.
That's all you can tell us.
Yes. You can't say much. About it. Or you want to know the actual investigative steps?
It's still sitting at IOCO.
No, if you say sitting, it's as if it's there and it's not moving. Investigation takes time. That's why I gave you the timeline for Wontumi. They started investigating Wontumi since 2020. If you look at the docket, since 2021. Okay. See how long it took for him to be charged, to even be arrested and be charged and brought to court. January 2020. We started the trial January 2020. So
what assurance can you give the Ghanaian people who are watching that, look, we are as much interested in this one as we are?
I don't even need to give further assurance. I just have to refer people to history. President Dramani Mahama had prosecuted his own appointees and they were found guilty before. That should be enough confidence to everybody that this is not a president or this is not a government who would close. The president will not, the president I know and we Ghanaians know is not the kind of president who would clear his people and be what? Prosecuting other people, other members of other political parties. He's done it before. His own appointees, he's prosecuted them, they've been found guilty and have been sentenced and have served the sentence fully. So it is not something that I think the average Ghanaian or the typical Ghanaian would be worried that President Mahama will cover up for his appointees. It is just, that's what I keep saying, that when you listen to the minority and you run what they say through the facts, you see that There's no basis for most of the things they say.
We have 2 other cases against him. The one in which he has a plea bargaining proposition to the Attorney General's office, and another illegal mining related one as well. Let's start off with the plea deal. Where are we with that?
They made a plea proposal of what they want to offer. We, in our opinion, they've not satisfied us, so we intend to reject it. In fact, we have in our minds rejected it, just that we've not had a meeting with them to inform them of our rejection. So it's like any bargaining. You give, you take. So we were supposed to meet yesterday, but of course what happened yesterday couldn't allow the meeting. And we are still trying to get that meeting done before we go back to court next week.
What was brought to the table that you're rejecting?
So they offered to pay some amount.
How much?
No, that is, it's enough that we are still bargaining. But the plea bargain itself is supposed to be, it's not supposed to be out there. When we finish, we announce the conclusion. But they made an offer. It's enough for the public to know that they made an offer which we found inadequate, and we're going to meet them to inform them of our rejection. And then,
without giving numbers, what would look like a proper proposition or proposal to the Attorney General's office?
I mean, for example, we ought to pay all the money with interest. I mean, otherwise, then what's the point?
We can conclude that was not what was brought to the table.
Well, that is not.
We can draw that conclusion.
I don't think you can, but if you want to, that's also fine.
We sent a team to go there today, and so they visited him. They allowed one person to go and see him, and they were able to give him the immediate toiletries that he needed, because yesterday he was just whisked immediately from the police from the police headquarters immediately after court. And I'm told that he's doing very well. So the campaign Chairman Jordan Go, together with members, visited him.
I see, but did you just give us an idea of his general countenance, what you were told? Because you say that a team went, you didn't go, but his general countenance when they saw him, how was he looking, and what did he say to them if they told you?
Well, I mean, obviously, waking up on your bed in Accra and sleeping and waking up in a different place is not one that anybody would expect. And so, I mean, they said he's okay. But yeah, I know that Chairman has a strong spirit, like I've already stated. He's a strong man. Yeah, I mean, I would see him hopefully before the week goes to a close. So I can be able to confirm a lot more when I've seen him face to face, rather than relying on what people have said.
Right, but also I recall, and this was a question that Kemini Amano did put to the Deputy Attorney General regarding what Andy Apiakubi, the former lead counsel for Chairman Wontumi, said yesterday when we spoke to him. He said that before Chairman Wontumi was, in fact, before he entered the courtroom yesterday, he called him, Andy Apiakubi, in the morning to say that, you know what, if I am handed a jail term, just prepare to appeal for me. And the Deputy Attorney General said he found that quite strange, that if Chairman Wontumi himself had indicated that he has changed his lawyer, now represented by Samuel Atachia, how is it that when he was going to court in the morning, he called his former counsel to prepare an appeal for him if he is jailed? Did Chairman Wontumi give you any idea that he was indeed aware that he could be jailed yesterday before going to court?
Well, Chairman Wontumi didn't give me any indication that he was aware he was going to be jailed yesterday. Like I said, we have always gone to court and we have always come out, and so that has always been our modus operandi as abidance of the rule of law. And so we had no indication that that was going to be the verdict of the court yesterday. Like I had already stated, that there were 2 motions that were pending for the judge to hear and also to stay the execution of the judgment or the pronouncement of the judgment. But she threw both cases out. And so we didn't expect that Chairman Wontumi would receive the final judgment yesterday.
But if you say you didn't expect, I mean, the judgment day, the date for the judgment was publicized before yesterday. We all knew the 20th was the day after it was postponed from July 3 because of the concerns that the new counsel, Samuel Atacha, had, that he had just taken over the case, he needed some time and so on. So we all knew ahead of time that it was going to be yesterday. So why do you say that you weren't expecting that the judgment was going to be given?
Absolutely. I mean, there are a number of times that cases are supposed to be heard in court, and those cases are either adjourned or not. And so the fact that it was declared that judgment was going to be made, and also there were standing legal cases in terms of motions, interpretation of some aspects of concepts of the Constitution, which was at the Supreme Court, and then also the stay of execution of the pronouncement of the judgment because the lead counsel was out of the jurisdiction and is yet to be in the jurisdiction tomorrow. And so the judge could have decided to stay the pronouncement of the judgment, call for the judgment on Friday, call for the judgment next week. I mean, there are a number of days before the month goes to a close. So the judge had a lot of opportunities to do that. I mean, if you know what I mean. But I mean, she decided to throw out the hearing.
Right.
Was interpretation. She gave her own interpretation, and she went ahead to do the same thing.
Right. Dr. Palgrave Boakye Dankwa, thank you. Thank you for joining us here on Ghana Tonight. Spokesperson for Wontumi's campaign team. Is still nursing that ambition to lead the party as its national chairman. We understand they are banking their hopes on the possible appeal and what the outcome will be. It's a matter that we'll get into as well. But coming up here on Ghana Tonight, let's move away a bit from matters of Chairman Wontumi. Well, so that's just a portion of the full interview that my colleague, that's Kamini Amano, had with Dr. Justice Demsrem earlier today. But what bothers on Chairman Wontumi is what you've just heard him talk about, answering some of the questions that the NPP has been putting to this particular judgment after it was handed Chairman Wontumi yesterday. 20 years jail term with some fines as well to pay. He says he doesn't see any path to an appeal. The NPP and the minority clear in their minds that they are going to appeal this particular ruling. The full interview will be played in the coming days, so watch TV3. But one person who is quite close to Chairman Wontumi, he's been seen in and out, or he was seen in and out of court with him, accompanying Chairman Wontumi before yesterday. In fact, yesterday in the morning, before Chairman Wontumi was told the judgment by the trial judge, he was with him in court in the morning. I'm talking about Dr. Palgrave Boakye Dankwa. He is the spokesperson for the Wontumi for NPP National Chair campaign team. And he's joining us on the telephone for a quick conversation. I thank you very much for joining us here on Ghana Tonight, Dr. Palgrave Boakye Dankwa. Yesterday when we spoke, you indicated to me that you were going to visit Chairman Wontumi in the Nsawam Medium Prison today, this morning. You'll be there to give him breakfast and so on. That's what you said. Did you do that?
Well, we had other.
I'm in the PENDREAM TV. Now, so far so good. Say open online portal in Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.